And now the Chair recognizes Mr. Sands for 5 minutes.
Mr. Chairman, honourable members of the committee, it's my privilege and honour to appear before this committee to address your questions on the subject of administration lawyers and interrogation rules. As Professor of Law at University College of London and as a practising member of the English Bar, it may be said that I appear before you as an outsider. I hope that you will bear in mind that I'm from a country that is both a friend and an ally of the United States, and one that shares this country's abiding respect for the rule of law. I'm also from a country which was on the front line of terror in the 1970s and the 1980s, a period I personally remember. I've come to know America very well over more than 2 decades, since I was first a visiting scholar at Harvard Law School and then taught over more than 15 years at Boston College Law School and then New York University Law School. I'm married to an American. I'm deeply proud of the fact that my 3 children share British and American nationality. Last month, I published an article in Vanity Fair magazine, The Green Light, a copy of which is attached to my statement. It contains material drawn from my new book, Torture Team, that is published this month by Palgrave Macmillan. The article, and in more detail the book, tell an unhappy story. The circumstances in which the United States military, not the CIA, was allowed, by the hand of Secretary of Defense Donald Rumsfeld, to abandon President Lincoln's famous disposition of 1863 that, and I quote, military necessity does not admit of cruelty, end of quote. On the 2nd of December 2002, Secretary Rumsfeld authorized the use of new and aggressive techniques of interrogation on detainee 063. It's by now a famous memorandum, the one in which he wrote, and I quote, I stand for 8 to 10 hours a day. Why is standing limited for 4 hours? End of quote. Approval was recommended by Mr. Rumsfeld's General Counsel, William J. Haynes II. The memo became public in June 2004 as the administration argued that the appalling pictures of abuse at Abu Ghraib were unconnected to administration policy. My book tells the story of that memo, the circumstances in which it came to be written, the circumstances in which it came to be rescinded. To write the book, I journeyed around America. I met with as many of the people who were directly involved as I possibly could, and I met with a very great number. I was treated with respect and with hospitality, for which I remain very grateful. Over hundreds of hours, I conversed or debated with many of those most deeply involved in that memo's life. They included, for example, the combatant commander and his lawyer at Guantanamo, Major General Dunleavy and Lieutenant Colonel Beaver, the commander of United States Southern Command in Miami, General Hill, the chairman of the Joint Chiefs of Staff, General Myers, the Undersecretary of Defense, Mr. Feith, the General Counsel of the Navy, Mr. Mora, and the Deputy Assistant Attorney General at DOJ, Mr. Yu. And I met twice with Mr. Rumsfeld's General Counsel at the Department of Defense, Mr. Haynes, who, along with Mr. Addington, took a central role on the key issues. From these and many other exchanges, I pieced together what I believe to be a far truer account than that which has been presented by the administration. I met men and women of integrity and decency and professionalism, obviously doing the very best they could in difficult circumstances. Sadly, not everyone I met fell into that category. From these conversations, it became clear to me that the administration has spun a narrative that is false. It claims that the impetus for the new interrogation techniques came from the bottom up. That is not true. The abuse was a result of pressures and actions driven from the very highest levels of the administration. The administration claims that it simply followed the law. My investigation indicated that, driven by ideology, the administration consciously sought legal advice to set aside international constraints on detainee interrogations. The administration relied on a small number of political appointees, lawyers with no real background in military law, with extreme views on executive power, and, frankly, with an abiding contempt for international rules like the Geneva Conventions. These are rules that the United States has done more than any country to promote and put in place. As a result of these actions by the administration, war crimes were committed. I have no doubt that Common Article 3 of the Geneva Conventions was violated, alongside with various provisions of the 1984 Convention prohibiting torture. The spectre of war crimes was raised by the United States Supreme Court, by Justice Anthony Kennedy, in the 2006 judgment in the case of Hamdan versus Rumsfeld, a case on which I noted Mr. Rifkin was conspicuously silent. That judgment corrected the illegality of President Bush's determination that none of the detainees at Guantanamo had any rights under Geneva. Mr. Chairman, honourable members of the committee, the story I uncovered is an unhappy one. It points to the early and direct involvement of those at the highest levels of government, often through their lawyers, the individuals on whom I largely focused. In June 2004, after the scandal of Abu Ghraib broke and the 1st of August 2002 BIBU torture memo became public, Mr. Gonzales and Mr. Haynes appeared before the media to claim that the Bush administration had not authorized such abuse. Contrary to the impression given by the administration, repeated by Mr. Haynes when he appeared before the Senate Committee on the Judiciary in July 2006, his involvement and that of Secretary Rumsfeld began well before that stated in the official version. Mr. Haynes had visited Guantanamo together with Mr. Gonzales and Mr. Addington, discussed interrogations, perhaps even viewed an interrogation or more, and then recommended that the US military should abandon its tradition of restraint. My conclusion, on the basis of large numbers of interviews and documents, is that this is not only a story of crime, it is also a story of cover-up, to protect the most senior members of the administration from the consequences of the illegality that has stained this country's reputation. Mr. Chairman, no country has done more to promote the international rule of law than the United States. Uncovering the truth is a first step in restoring this country's necessary global leadership role, in undoing the damage caused, and in providing a secure and effective basis for responding to the very real threat of international terrorism. I can put it no better, sir, than George Kennan, the great American diplomat. In 1947, he wrote an anonymous telex that issued this warning in relation to a perceived Soviet threat, and I quote, "We must have courage and self-confidence to cling to our own methods and conceptions of human society. The greatest danger that can befall us is that we shall allow ourselves to become like those with whom we are coping." End of quote. I thank you, sir, members of the committee, for allowing me the opportunity to make this brief introductory statement.
I thank you, and I thank the other witnesses.